Swayam Prabha. Digital India. Educated India.
Welcome to the course Environmental Impact Assessment. For the past weeks, we saw the environmental status and then looked into need, purpose of EIA and evolution of EIA, particularly in USA and in India. Then we also looked at the global timeline to understand what kind of law and policy and institutional arrangements are there and how do they align with the larger objectives. So now we will start looking at law, policy and institutional arrangements for EIA systems at the global level. So the key reference is the UN Training Manual, Chapter 2. The link is provided in the reference section for you. So the coverage for today would include that we'll be looking into the key trends in the development of EIA systems. We'll look into the foundations of an effective EIA system, like what are the characteristic or the context which makes EIA effective. Further, we'll look into like the framework of EIA, and we'll look at from the legal perspective, from the law perspective, how we apply that. Further, we'll also look at the enabling environment for EIA and like what are the context support that EIA needs for it to be really implemented and reach to the sustainability goal. Lastly, we'll look at the relevance of why we need to really know about the legal aspect, all these institutional aspects, and then we'll also look at certain concepts just for clarification purpose. So the learning outcome, what is expected out of you after completion of this particular session is that you should be able to discuss the key trends in the development of EIA systems, and you may note that this is an evolving system, so you need to take everything in perspective. And then you need to identify foundations of an effective EIA system, what are those, and then review framework for EIA from the legal perspective. Then you should be able to identify the key elements of enabling environment for EIA and sustainability, and then discuss the relevance and describe various concepts. You should be able to differentiate between the legal, policy, and the institutional setup, which we'll do in due course of time. So recapturing the key trends in the development of EIA system in our week 2 lectures, if you may recollect, while looking at EIA impacts, we saw that EIA systems have become progressively more broad. So there were a lot of things which we talked about, how EIA is taking newer topics and wider topics here. So it's covering wider and new range of impacts, and there are multiple levels of decision from local level to the international level. So there are a lot of changes which have happened in EIA. So we see that it's more systematic procedures have been followed for EIA implementation. There are improved quality control, how the how the standards have to be followed, how the compliance has to be there, and how EIA would be enforced. Further, we see that there's a lot of consideration for integrated approach, and like not only taking the biophysical, but as well as looking into the social risk, health, and other impacts. Further, we see that in EIA now we have extended framework where we look into temporal as well as spatial impacts, and which like for the temporal, you can see that we have been started talking about the cumulative impact assessment. For the spatial, we are not just talking at the national level, but we are talking at the transboundary level, and then we are also talking at the ecosystem level, and then looking at also looking at the global change. So now there's also increasing concern for making provisions in the framework for strategic environmental assessment, which is also said as called as SEA, strategic environmental assessments, which appears at early stage. So you know about EIA, so SEA appears at an early stage of project design, and it facilitates the decision on the design and the location from policy, plan and program proposal. So compared to EIA, it comes at an early stage and it allows a lot of flexibility in how you approach your project design. We will look at SEA more in detail in the later part of our lectures, and will also differentiate it from EIA. So we see that there is also increasing, or it emerges from the concept of sustainability, and then these sustainability perspectives and principles have been incorporated a lot in EIA as well as in SEA processes. And then we also see that now we are starting to have greater linkages of EIA systems with the other planning, like urban planning, and then also sectorial planning, so that all integration is happening, and then also with the regulatory system as well as the management regime. And EIA has also become much more institutionalized now. So you may also refer, like in order to like have a review of the context, you can also see international study of environmental assessment effectiveness, how these systems are effective. We can look at the Handbook of Environmental Impact Assessment and the Environmental Assessment Source Book. You can look at the updated issue by the World Bank. So let us first look into the foundations of an effective EIA system. So like what really makes EIA effective, what are the key characteristics, which one as a reviewer, when you are working on it, looking at a system, reviewing a system, what aspects you should look at. So, so that wherever the EIA is applied, or where you're reviewing for the improvement purpose, you can see what makes a system workable and it makes reach its goal, and here we mean to say sustainable development goals. So EIA system should have one, that it should have clear foundation in law and regulation. So it should have distinct bases in law and regulation, and then it can be really translated into any nation's system here. For example, we see in India, EIA system is well established within the legal system. So on the left hand sides of the image here, you can see the Environmental Protection Act, which was enacted in 1986 with the objective of providing for the protection and improvement of the environment. So that's how we have the act in place to facilitate EIA system. On the right top, you can see within within this the ministry is conferred power, and the power which you can see the list of powers that include environmental clearance, and this I've taken from the ministry site. And on the right bottom, you can see notification, which specifically addresses and guide clearance process in the country, in our country. So in any EIA system, the framework should provide clear statement of objectives and requirements. So that clarity is very important, because it might lead to a lot of interpretation. So the EIA statement, the purpose should be very clear, and what is required has to be clear here. So the Environmental Protection Act 1986 clearly states the purpose. So the purpose, you can see the protection and improvement of the environment and for matters connected with it. So it's broader, and it really tells that it's concerned with the environment for the purpose of protection and improvement. So I've taken a snip from the Environmental Protection Act 1986 here for your reference. So here we can see in the EIA notification stating which development activities will require environmental clearance. So you have entire list and which have been provided here. It should have, like you also see that the EIA should have a mandatory compliance and enforcement. So for which the act is formulated and bodies are set up with the power at central, regional and state level. So wherever the system is, one needs to ensure that it's mandatory and it can be enforced. So other aspect which we see is that the EIA system should be comprehensive in scope. So it should allow coverage of all the environmental aspects for the application to proposals with potentially significant impact. So whatever proposal can have significant impact, they should be included in the process. So your system needs to be comprehensive in terms of scope. So in our case, as we had seen while introducing EIA in India, that we follow list system based on category and defined threshold levels. I have just provided the snip of it here. Link is also provided to you for downloading the list here, so you can see how those categories are defined here and which one will go to which level for scrutiny or will not be applicable for EIA. So that is how we do it, undertake it. So when we compare this with NEPA, we saw that NEPA had a broader statement which is subject to interpretation and is supported with guidelines as already seen before. We have reviewed that. So you see that compared to them, ours is very specific. We follow a list whereas they have a system of reviewing it and then considering it for the EIA purpose. So EIA system should also prescribe the process of steps and activities which will be taken. So there needs to be clarity in how it will be done. Here you can see EIA notification 2006 provides clearance process. You can see here the stages mentioned. So you can see the stage like screening, scoping, public consultation, and how the appraisal has to be taken care of. We also saw in NEPA section 102 which defines the procedural requirement for the preparation of an environmental impact statement. I have just taken the snip for your reference. NEPA document link is also provided to you, and we have already discussed that. So you can see here how within the NEPA 1969, the section 102 provides the procedural requirements. So entire few pages are there which really gives you what should be considered, how it should be considered. So those are mentioned in the Act here. So EIA system should also prescribe the procedure and steps and activities which have to be followed. So here we see that EIA notification in its annexure provides procedure for conducting public hearing. So you see that how public hearing can be done here. So entire procedure has been given here. And further, the EIA system should have linkages to project authorization, permitting and conditioning the setting. So all this who will authorize it, where the permission will happen, and then the institutional setup. So if you recollect that we saw in NEPA the setup of the organization, and here in India we see that there are various sectors which integrates with the process, and then you see CPCB provides support and guidance, and then there's also CPCB provide technical services to the ministry here. So you can see the snip from the website. So that was about the foundational element, what really makes EIA effective in any system. So you saw like range of things which should be there, from the legal aspect to the process aspect to the linkages aspect, public hearing aspect. So all those really make it possible for EIA to be translated on ground. So now looking further, like looking at EIA from the legal perspective, what all should be there so that not lot many litigation would happen with it. So it should cover broad definition of environment and effects. So your act, the statement which you have, should have the broader definition of environment and effect, and it should identify duty and particularly to avoid, mitigate or remedy adverse effects arising from any activity. So it should allow you to have those kind of range of duties, like there should be no conflict of duty. You should be able to have powers to mitigate or take actions to control the adverse effects. So you should the statement, the system should also provide details for like what EIA report should have, and then it should make provision for mitigation measures, what mitigation measures the proponents intend to apply. Furthermore, you will see that the procedural guidance should also be given on compliance and good practice in applying EIA arrangement, and whenever whatever decisions are made, those reasons should be given for their decision, why that particular rejection or improvement or acceptance was done. So those reasons have to be clearly stated. So such kind of things, when they are clearly explained, then it safeguards the system from the legal concerns. So you can see here from the snip given here, so from the Environmental Protection Act. So you will see, look at the definition here, range of definitions of the environment provided to you. So you see how it clearly states what all things would be covered here. And then in terms of all the duties which would be there, so it also lists all the duties here. So the amendments to the rules, coastal regulation zone, delegation of powers, and then how they have the right to have eco-marks schemes, zones, and environmental clearance, all these things. You can see, so all these duties are clearly stated. And it also provides, the Act also provides the outline of EIA document. So this I have taken from the 2006 notification. So all the acts are regularly amended to make it flexible to accommodate all the changes which are going on. Further, we see that now moving on. So that was about how we really have an EIA system which can be legally protected, then to a certain extent, and then now looking at the enabling environment. So what kind of support is needed for EIA? So we see that there needs to be a functional legal regime. So there should be things which allow functional working, and we need to have sound administration so that it can be applied, and then the flexible policy making. So flexibility is very important here because constant changes takes place in terms of technology, in terms of relationship, in terms of policy and context as well. So it needs to have flexible policy making, and then also stakeholders' understanding of the aim of the process and its potential benefits should also, that also, like stakeholders' understanding also influences how the EIA is implemented. Further, we see that political commitment is also very important, that there should be willingness to implement EIA. And apart from that, in addition to the political commitment, one also needs to have institutional capacity for implementation. You need to have institutions, you need to have people the technical capacity, and then you also need to have data and information so that all the work can be executed in a quality manner. And then there's also need for public involvement, as well as you need financial capacity to undertake it. You would need money, resources, time, people, all of these. So when you resource channelize this, create an enabling environment, then the EIA can be really implemented to its potential. So now coming to our last segment here, looking at the relevance of understanding the legal policy and institutional arrangements. So why really as a learner we need to understand that, and like what direction, what EIA system, different directions it takes. So looking at that, how EIA is applied in any country, how it meets the goals of sustainable development, can the EIA be improved through a better understanding of like what kind of arrangements are there. Every country can have different kind of arrangements, somewhere it can be mandatory and somewhere it might not be mandatory. So and it would largely depend on context to context. So therefore it is important for you to understand what different arrangements are there in a country at different levels, which we're going to see in sequences now. So in any country, provisions are made in terms of law. So mostly you will see that for EIA, the provisions, or for any, the provisions are made in terms of law. Which is a rule. So and then, or you also see that provisions are made with respect to policy. And what is policy? Policy is a like set of guidelines, and you also require institutions which facilitate the activities needed under the goal. So whatever goal you want to achieve, so you would need a law in place, you would need policy in place, and you would need institutions in place. So further, you would also need procedures, and usually procedures are set, like how it will be undertaken, what procedure would be followed. So all of these factors contribute to the success of EIA. So it is important for you to see the strength and weakness. So whenever you review it, you see what strength and weakness particular existing arrangement in your country is there, and for whichever region you're looking at, and how EIA can improve as a tool to achieve sustainable development goal. And each system is contextual, so it's very difficult, or when you adopt like a EIA system, there will be a lot of significant adaptation required, because you cannot really transfer EIA from one system to the another. So keep in mind that every EIA system is typical, unique to certain extent. So EIA in one country would not be really applicable in the another. So every EIA system reflects political system of its country, or what kind of system they have, and one cannot import one EIA framework to the another context. So that one needs to look at the same time. We need to, at the international level, global level, that's a lot of integration which is required, because we might be working at the international level, at the global level, to meet the larger objectives. So there would be contextualization as well as some kind of standardization. So while you look at any EIA system, what do you really look at? So like you look at who is the authority responsible for seeking the implementation of EIA procedure. So who is going to do that? Who will have the power to do that? So check and review the requirements for public participation. So you should see that how public is participating, how aware they are, how informed they are, and whether it is mandatory or optional procedure. So in your country, it could be mandatory or optional procedure as well. Like in India, we saw it's by the law, and like how it has been taken care of, and where all how the overall procedure is, and at where all the quality control is being done. So that all you should review while you look at any system. So while you see one of the key element, public participation, participation may vary from country to country, reflecting different traditions and style of governance. So it will depend on that. Some countries have established a separate EIA authority. In other EIA processes administered by the environmental department or the planning authority. So looking at the authority aspect, you might have independent as well as like it could be part of a bigger thing. So no single EIA model is appropriate for all the countries. So not only within country, but there is a need to be coherence between EIA requirements of various governments or agencies. So like you need to have coherence to avoid uncertainty and confusion and added expense for the proponents, the people who propose the project. So for example, countries receive aid from number of donors, each having its own prescribed assessment process. So all the donors would have different formats. So and then the proposal could be also at the transboundary level, and it would require compliance with EIA procedure for more than two or even more countries or states or levels. So that ways we need to have coherence. And for example, like you have already seen ESPO convention. So there you see how different states and different countries would work. So there's some coherence which is needed. So looking at the legal aspect, policy aspect, which we will be looking at series of lectures now. So building on some conceptual understanding. So EIA takes place within the legal and or a policy framework. So it will have through the legal setup or the policy setup, or it can be both. And it is mostly established by individual countries and international agencies. So if we quickly want to understand the difference between the two, like what's the difference between the legal and the policy, law is a formal document and administered by judiciary. So that's like one has to follow that, whereas policy is a reference for working of the government. So it's a reference like how they would really go about it, and it is administered by the government. So laws are established in order to bring justice to society and equality. Whereas policy is made for achieving certain objectives by the government. And the key element here is that non-adherence of law is punishable, whereas non-adherence to policy does not lead to severe punishment. So that you need to understand here the difference between the law and policy. So looking at the international environmental law and policy of relevance to EIA. So significant developments has taken place in international environmental law and policy, which are relevant to or applicable by EIA systems of all countries, as you see here. So they can be like these can be divided into non-binding and binding. So you can have instruments which can be non-binding instruments. For example, we have seen Rio Declaration, which is non-binding. So there was a common concern that people want to achieve, the nations want to achieve it, but it was non-binding in nature. So it established important principles for sustainable development, including those which needed to be reflected in EIA arrangement. And then we also see that it also was guided by the precautionary principle. And then there are binding instruments. These instruments are the legal conventions and treaties related to environmental protection at the global or the regional level. So there are non-binding and then the binding. So they carry obligations. So when they are binding instruments, so they carry obligations for signatory countries. So if we are the signatory, then we are bound by that. That may be met through like that can be taken care through the EIA arrangement. Legal conventions and protocols that apply specifically to EIA arrangement, of which ESPO convention. So if we are signatory to ESPO convention, then we are bound by that convention. So EIA is specified as a mechanism for implementing certain aspects of both agreements. So in EIA also you have certain non-binding and certain binding elements. So more generally, it can ensure that proposed action of the signatory countries are in compliance with these and other international environmental agreements. So we have seen all the series of those agreements. You may also find that agreements are also classified as green agenda, green list, or brown agenda or brown list. So just for your information, green list covers natural element, brown list is associated with human activities. You can see the examples here. So you can see how Convention on Biological Diversity, Convention on International Trade in Endangered Species, we had seen all of that before, Convention on Wetlands. So these are all green agendas, whereas you see the brown agendas, for example, like control and prevention of pollution, so Framework Convention on Climate Change, which targets on greenhouse gas emissions, like, and then the protection of ozone layer, then control of transboundary movement of hazardous waste, so they all become brown agendas. So these examples are given to you just for review purpose. So then we also see that within the legal provisions there are like you have general environmental law. So you also find these kind of categories, and also environmental protection, like general environmental law, like for example we saw NEPA, and which we have which is an umbrella law. So within that everything else comes, and also Environmental Protection Act 1986 is general environmental law, and these incorporate the EIA requirements and procedure like you saw in the set of duties which were there. And then comprehensive resource management and planning laws are also there, like you have New Zealand Resource Management Act, which provides how the overall resource should be planned and managed. Then you have specific enabling or framework, EIA law. So that's like European directives. So then you have comprehensive or perspective law like CAEE, which is from Canada, you see here. So we have already seen NEPA and Environmental Protection Act. We can just look at New Zealand Resource Management Act, which is internationally the RMA is significant as sustainability benchmark. So this was formed following years of process of law and government. So RMA is an like umbrella law, meaning a collection of law, omnibus law, which like it cancelled all other laws, and then it came as one umbrella law. And within the single rule, with the purpose of promoting the sustainable management of natural and physical resources. So not just by the element of EIA, but with all the other management aspect, this is taken care of. And Section 5 from this Act defines sustainable management, among other things, as like what all things need to be avoided, what needs to be remedified, and those things. And it also imposes biophysical tests of sustainability on activities. We see that RMA does not define an EIA process. So like how different EIA system can vary, here you see that RMA does not define EIA process. However, they have detailed guide for good practice issued by Ministry of Environment. So looking at Canadian Environmental Act, CEAA, so this is an example of comprehensive EIA specific law passed in response to the series of legal challenges and ruling on the previous 1984 guidelines order. So there are certain key aspects to it, like it has principle of public participation, it designates responsibilities, it prescribes requirements like what fundamentals we had seen before. Then Act applies it only to the projects, and there is also provision for SCE process here. So looking at the format or the layout of the European Commission, directive on EIA, we see that EIA directive is a framework law. This law is binding upon member states, and the law sets out the principles and procedures. So it is also giving principles and procedure, and it also leaves certain discretion on the member states that they can create their own national legislation. And with regular amendments to directives, the processes are refined, like screening, consideration for alternatives, public consultation, and decision making. So all these are strengthened. And it also has provision for SEA or for like reviewing the plans and programs. They have a formal system for this. So EIA directives is in force since 1985 and applies to wide range of defined public and private projects. And then the link is provided to you for detailed understanding here. So, and how is the review also, it's given to you for further study. And then looking at the key provisions, like what really European directives have. So it gives you like remember the fundamentals. So it gives the broad definition, it has mandatory application, and then it gives the requirement to submit, what kind of submissions have to be done, what kind of informations have to be given, and how the alternatives have to be studied and justified, and how the submissions have to be made available for public comments, and what results the consultants get, and the content and reason for decision. So all these aspects are there in this directives, which is like fundamental to the EIA system. So we see that it contains all of it. So this was what we covered today, and we'll be looking more into this, the legal aspects of it. So just to summarize what we covered today, so we looked at the key trends in the development of EIA system. We looked at what are the key elements of an effective EIA system, and then we looked at from the legal perspective, and also looked at the enabling environment, and then the relevance and the concepts of it. So that was for today. So these were the references which we used for this particular session, and these are the suggested watch and read for you. And please feel free to ask questions. Let us know about any concerns you have. Do share your opinion, experiences, and suggestions. Looking forward to interacting and co-learning with you while exploring EIA. Thank you.